I served in Parliament. Oh, okay. Ellison, I was just saying that your introduction is like a pig being prepared for the slaughter. The knives are yet to come. I'm honored to be here. I usually listen anonymously in order not to provoke the host to say, I have seen the minister online, can he address the question? So I have to start by confessing. I served with a relative of yours in the parliament. I was his campaign manager when we wanted him to go to Iyala. Our plan then was for him to become the first speaker of the East African Legislative Assembly. Unfortunately, his own party fought him bravely, which was quite interesting. But what I remember is that he saved a motion which was about to fail. There was a motion in Parliament to inquire into why the war in the north is not ending and what possible solutions are there. It was brought by Agri Awori, Zachary Olum, and a few of us. And the motion was about to be put to a vote, and the tyranny of numbers was about to be unleashed. And then the Honorable Eli Karuhanga stood up, and the Speaker recognized him, and he said, Mr. Speaker, we don't need to vote on this. Everybody is being affected by this war. Will you give us a few minutes in the lobby so that the movers of the motion and those opposed to the motion can have a meeting with the Prime Minister, and we will come back and report if we get a compromise. And the compromise was got, and instead of setting a select committee, something which the majority didn't want, the matter of the inquiry into the war in the north was given to the Committee on Defense and Internal Affairs. Now, that is what we call statesmanship, focusing on solutions. And I hope all of us start thinking beyond our battle lines. Now, I served faithfully as a project advocate of the Uganda Law Society. And because the war was raging, curiously, I was the only applicant for the job. I've never had such pleasure in being interviewed. In fact, it was not an interview. The Honorable Lady Justice Salome Balungi Bosa simply subjected me to some form of counseling, telling me not to be afraid. The Law Society would support me even if I was going to be in Gulu. And the salary was good. At that time, it was $350. Made me very popular at wedding meetings. I could at least contribute. Before that, I'd worked with the Kabugo and Company advocates, and it is Kabugo Charles who also paid my nomination fees for the parliamentary elections, because my campaign war chest was a hefty 60,000 shillings. So I had to close the gap with my wits. And then the traders in Gulu came in. I joined Makerere University from Namilyango College. Ours was a very, very small class. Among my classmates are two Supreme Court justices, that is Justice Catherine Bamugemerere and Justice Monica Kalyejira Mugenyi, and the justices of appeal like Helen Abulo and John Mike Musisi, and many. We believe that the practice of the law is an extremely noble profession, and I still believe that Ugandan lawyers are among the very best worldwide, and they have distinguished themselves in many places. I should say and the context starts with a question, because the thread running through this topic is really the role of the state. We cannot talk about the state of justice without talking about the state. So eventually we are going to have to talk about the character of the Ugandan state. And unless we are pretending that we are in the library. But if we live in the Republic of Uganda, rubbing shoulders with the 46 or 47 or maybe 48 million Ugandans, then we have to talk about the state. We ask, what is the role of the state? And I'll mention 4 roles. The first is, of course, to protect our territorial sovereignty. That's for us, we are supposed to be rubbing shoulders with the police. Most probably the police carrying batons, or even just warning us, not to misbehave and things like that, talking to us like good neighbors wearing uniform. So the first role of the state is that nobody should mess with our borders. Number 2 is to protect all the citizens from being molested by other citizens. In other words, to enforce law and order. No one should come and steal my property. Nobody should rob me. Nobody should beat me up just because they are big and so on. That's the second role, and the state should always be stepping in to stop that. And number 3, the state also establishes the laws so that the do's and don'ts are very clear. Fortunately, we all know that laws are supposed to be written. Laws are not supposed to be people's opinions or the views of those who have power. They are supposed to be written so that they can be quoted. The other reason why the laws need to be written is because everybody needs to wake up in the morning and they are told the laws are still the same unless Parliament has changed them. And then finally, settling disputes when citizens are quarreling among themselves as to whether the law is being applied properly or not, whether they are disagreeing about contracts. The state has that duty. Now, an answer to the question of the state of justice in Uganda must obviously start with the
space has ended.
The question of how good are our laws.
Sorry, the space has ended.
Our network has collapsed.
Mine?
No.
Wi-Fi. The Wi-Fi is very unstable.
I'm not on Wi-Fi.
No.
No, I am.
It is the first. Wait, they said you need to start another
So
link.
once in a while, the space just crashes because of their like technicalities. So let's try and just get another link and restart.
Okay.
We had about 500 people.
I saw even before you started.
Saying that
We are live on YouTube. Our space has on X we've lost our audience on X, but we are starting it again in a few minutes. One time, as we keep saying, Elon Musk's space with Donald Trump collapsed. So we are not doing badly ourselves. And I think I'm starting the space now. But for our YouTube audience, thank you for staying with us. And yes, I've just started the space again. Yes. Mercy. Apologies, colleagues. We had a technical glitch, as I was explaining to those who are on YouTube with us. One time, the space between Elon Musk and Donald Trump crashed, and so you can just tell that this is one of those. This is one of those historic spaces, clearly. I see the Honourable Minister has joined as well. So if you're just joining us, you'll forgive us. We had a small technical glitch, and this small technical glitch was caused by matters beyond our control. The space crashed on X, but those who are on YouTube and I believe TikTok were still with us. And as I had said, one of the challenges when you're having a historic space like the one Elon Musk once held with Donald Trump, these things happen. And I'm sure that you're all welcome to join us. I see many of the numbers are still coming back. Colleagues and friends, we have with us the Minister of Justice and Constitutional Affairs. We had introduced him before, but just for the completeness of the record, the Honorable, the Minister of Justice and Constitutional Affairs, the Honorable Norbert Mao, is our guest today. The topic is the state of justice in Uganda. We have a number of questions for him. For those who had not yet joined by the time we started, the Honorable Norbert Mao is an advocate of the courts of judicature. He is a member of the Uganda Law Society. He has ever served in the Uganda Law Society. That's where he started off. He was also a guild president of Makerere University, having won an iconic and famous election, I think in 1990, against the late Brigadier Noble Mayombo. He was a member of parliament for Gulu municipality, having served for 10 years after defeating then Minister Honorable Betty Bigombe. He was the chairman of Gulu district. He's the President General of the Democratic Party. I think he's a Yale Fellow, if I recall. So we are very honored and privileged to have the Minister of Justice, someone who has a deep understanding of the wheels of justice and how they move, who has served in them, who has served as a leader of conscience, who has served as a leader in politics, but who has a deep understanding of constitutionalism and law, and is currently serving Uganda as her Minister of Justice and Constitutional Affairs. So we thank you, the Honorable Norbert Mao, for joining us. Honorable, before we got interrupted by Elon Musk's technology, you were taking us through the state of justice in Uganda. I am Ellison Karuhanga. I'm joined also by Alfred Muyaka and Mercy Chemutai Makabai. Over to you, Honorable Minister.
Thank you, Ellison. Thank you so much, Ellison. Apologies accepted, and I hope Elon Musk is hearing us. We are all now cheering Donald Trump as long as these glitches continue. I had already mentioned what we need to look at in order to deal with the question of the state of justice. And I based everything on the 4 key roles of the state, namely the protection of our territorial sovereignty, ensuring peace and security in the realm, making laws, and then the settlement of disputes. For purposes of this discussion, we have to talk about security. Are citizens safe? In all discussions, we are always talking about the dichotomy of state security and human security. Whenever we hear Ugandan citizens talking in conferences, they accuse us in government of focusing more on the security of the state rather than the security of the persons. Now, to my understanding, this security is actually indivisible, because if the state is not secure, then there is no human being who can be secure. And you cannot pick and choose and say which one comes first. The security of the state is very important, and so is the security of the human being in the state, namely the citizens. At the Ministry of Justice, we often get a lot of complaints. We have a human rights desk, which is going to be upgraded into a fully fledged department. We get a lot of complaints. Members of Parliament call us, telling us about police high-handedness. For instance, a member of Parliament may be holding an event, like the lady who was holding a Women's Day celebrations in one of our islands, I think Kalangala, and then the police just arrived without warning and started beating up everybody and throwing tear gas. Then it is our duty to respond. And in this case, I called the Inspector General of Police, because now when a member of Parliament is complaining, the minister has to intervene. And then the Inspector General of Police says, well, tell the Secretary General of the party to which that woman MP belongs to report this matter to the police standards and have it investigated. Then it is my duty to call Mr. Rubongoya and tell him. Whenever we see cases of torture, we are proactive. We call. Now, it is important that these cases become the exception rather than the rule. So when the cases become too frequent, then citizens have a right to complain and challenge us to do better. When I joined the cabinet in 2022, I found that the cabinet had started a discussion on establishing a cabinet standing committee on human rights. It had stalled, so we resurrected it together with the Office of the Attorney General, and then we took the paper back to cabinet, and then cabinet approved our proposal, and we established the cabinet standing committee on human rights. The purpose of the cabinet standing committee on human rights is to deal with the powerful people. I give an example. One time we got a petition from fishermen. They told us that they are being terrorized on the lake, that the UPDF is all over the lake. The government policy at that time was that the fishermen should stop fishing so that they don't take small fish. Unfortunately, the Congolese love the immature fish, so we are fighting against the market. And of course, the army, they start with force and keep escalating the force. If you want to know the difference between the army and the police start without force. For the police, force is supposed to be a last resort. For the army, it is force first, and they keep escalating it, and if they have nuclear weapons, they will even drop it at a particular point. Now, the solution lay in calling the relevant ministers, because the Cabinet Standing Committee has got the relevant ministers. I chair that Cabinet Standing Committee on Human Rights. The deputy chair is the Minister of Internal Affairs, where the police falls, and the Minister of Defense is a member of the committee. The Attorney General is a member of the committee. The Minister for Gender, Labor and Social Development, which covers the youth, is a member of the committee. The Minister of Local Government is a member of the committee. The Minister of Foreign Affairs is a member of the committee. And the Government Chief Whip also sits on the committee. And ex officio, the Secretary General of the ruling party, also sits on the committee. So in the case of the complaints from the fishermen, we engaged the security forces, including the office of the CDF. The other thing was to go deeper. That's when we realized that the army is on the lake because the Ministry of Agriculture has not established the fisheries monitoring unit, which is supposed to do the job. Now, in our country, the army often has come in to fill gaps. They do so, obviously, but they do it militaristically. We have seen them filling vacuums in many places. When the Ministry of Agriculture and NADS were failing the president's agenda, they came in as Operation Wealth Creation. Now, like any army, when the army comes to fill a vacuum, they are easy to mobilize. They are very difficult to demobilize. It is not easy to say goodbye to the army once you have invited them. And anybody knows that. So that is one case that we got involved in, and I'm pleased to report that the complaints on the lakes have reduced. The reason why the Cabinet Standing Committee is important is because we also have a political lens. When we gave a report that the NRM virtually lost in all the districts bordering lakes, that was a red card. In that case, it is no longer about fish. It is also about a policy and actions that are undermining the legitimacy of the state. Right from Busia, Namayingo, all these Bujiri, you come to Jinja, all these Buikwe, all the way, all these areas around those lakes. So that is one thing that we have been able to do. The other thing which I would like to was having some initiatives of mediation, some kind of alternative dispute resolution. So the only thing I could sensibly do, given our limited resources, was because we believe that we earn our fees by bruising the other party. So we have to change our operating system. Now the judiciary has started changing their operating system, and they have been telling stories of intractable disputes being resolved when they are subjected to mediation. So immediately I made a decision to prepare a policy on alternative dispute resolution. Now, government is quite slow sometimes, and though there are many civil servants, they are extremely busy. When you are outside the government, you actually think civil servants don't work. Those of you who have ever been civil servants, you know that actually you work. But the rumor out there on the streets is that, civil servants don't work. The one thing I disabused myself of was the thinking that civil servants don't work. I actually discovered that these people really work very, very hard. So now I had to depend on external support. I contacted my good friend Francis Gimara, senior counsel, and my classmate Dr. Henry Honoria, and I asked them to start putting down some ideas towards the alternative dispute resolution policy, which I would take to cabinet. we prepared some decent paper. Then when the Pepperdine team was visiting Uganda, I mobilized the Attorney General to join a meeting, because the Attorney General is the chief fighter on behalf of government. With the policy, when we reached the Cabinet Secretariat, they threw it back at me and told me, no, there are some boxes that are not ticked. You need something else called RIA, Regulatory Impact Assessment. Some so-called experts go and sit in a hotel, and for about 3 or 4 days they answer some difficult questions, trying to peer into all the corners of DC. It is actually a very good process. At that time I didn't appreciate it, and I remember calling the Cabinet Secretariat and giving them a piece of my mind. I told them off. I just stopped short of insulting their mothers. But eventually, when I realized that what they were doing was actually for the good of my project, I called back and apologized to them. That was Miss Katuramu, the then deputy head of the deputy cabinet secretary. I apologized to her and said, forgive me. When I went for orientation as a minister, we were not taken through these things. Those who came to orient us were telling us how to hold glasses of wine, the length of our ties, and things like that. And anyhow, as I talk now, the policy has been approved by the cabinet, and we are now going to work on legislation. In other words, the mainstreaming of ADR is a very important move in ensuring that citizens can get justice quickly. The logic is simple. These cases are not cases about the goes to the villages telling villagers to come to court. No judge goes shop to shop telling people to come and file cases. The cases find them there. But many times the lawyers act as if they are parties also in these cases. As a court accredited mediator, I have had some experience where I've found that lawyers can also be an obstacle to the resolution of disputes. So all of us need to forget certain things that we were taught in law school. With the dissolution of CADA, I hope to hear the feedback on CADA, but it looks like from the time we set it up to the time it was wound up, it seems it suffered numerous ailments. So now we need to work with the members of the bar, who actually are the front line, to see how that department in the Ministry of Justice can serve ADR better. As of now, I believe there has been a recruitment of someone at the rank of a commissioner to head the department of ADR at the Ministry of Justice. We have found that by collaborating with the judiciary and by retraining ourselves, and I wish to thank Pepperdine University for allowing 11 of us to undergo a course that led to the award of a Masters in Dispute Resolution of Pepperdine University. And I believe many members of the bar should take up that course when there's next another set of enrollment. It is that qualification that allowed us to be recruited as court accredited mediators. And even yours truly would go to the court, report to the head of the commercial court, then report to the registrar, and then he is assigned the room and files. And even though I'm a minister, I sit at a desk with 2 clerks, and then I start mediating cases. And we have been able to mediate some very difficult cases. To me, that is something that is in line with our African tradition. The Chief Justice says ADR is not actually alternative dispute resolution. It is this Western system which is the alternative. That our African system, which we call ADR, is actually the original dispute resolution system. Now we go to laws. How good are our laws as I close? Because ultimately, even when it comes to how disputes are settled, it depends on the laws. I think from my own experience, I have found that there's a lot of political undertones in a lot of these cases. I'll frankly give my opinion about the Besigye case, because really there has been a lot of drama around that case. When the Supreme Court ruled that civilians should not be tried in the court martial except under exceptional circumstances, I went to Parliament, and the members of Parliament told me the Supreme Court has ordered the release of Dr. Besigye. What is the minister doing here? Let him get out and ensure that Dr. Besigye is first released. First of all, as a minister, I cannot pick a phone and order a judge to release anyone. If anybody believes that a minister should do that, then nobody should complain when a minister interferes in other cases also, whether they be land cases, whether they be criminal cases. We must have some measure of respect for the boundaries. So I was kicked out of Parliament. I tried to explain to the members that, look, there was no release order. Secondly, Colonel Besigye's lawyers took a very long time to take the next steps that the Supreme Court judgment required. They expected that the Attorney General would be the one to extract the orders. First of all, the Attorney General had lost the case. I've never seen a case where the loser of a case is the one who vigilantly goes to extract the order against himself. It is the winning party who should go and extract that. For 2 weeks, they were addressing press conferences until we spoke to one lawyer who was more level-headed, I guess Jude Biamukama, and we told him, why don't you help us? Because I was chased away from Parliament. The Minister of State for Internal Affairs was chased away from Parliament. Deputy Attorney General was chased away from Parliament. The Speaker didn't want to see our face there. And they said, go and tell the judge to release the Colonel Besigye. How can a trained lawyer go to a judge, even if you're a minister? So, through Jude Biamukama, the case was brought forward to the next day. And that is how the transfer started. The other reason is that the DPP is not the one who investigated these cases. So, while many cases have now been transferred, but they are being investigated de novo in order that somebody can prosecute. Probably the DPP is going to throw away many of the cases, actually, because most of the cases may be bogus cases. So if we want the state of justice in Uganda to improve, there is a need to not go too much into the politics of cases. There are many times I have called the NUP leadership and told them to activate the provisions of the anti-torture laws and the regulations, which are actually very clear. But instead, they spend a lot of time addressing press conferences and displaying the victims, instead of actually doing division of labor. I don't mind the drama of press conferences, but I think there should be lawyers and other legal professionals who should be fighting the cases and ensuring that the government is held to account. But now, if you're both a lawyer and at the same time the politician, then definitely that is going to undermine the enforcement of the rights of your client. As I talk now, I know for a fact that this matter of the court martial is likely to go back to court. When I went to Parliament and mentioned that in terms of percentage of cases, actually the cases that are in the court martial are not as many as people make them to be. But because of the prominence of those who are in the court martial, you would almost think every case ends up in the court martial. Lastly is the need for backbone by decision makers. I really would appeal to those who are at the front line. For instance, under the Prisons Act, if somebody is visibly sick, you are not supposed to lock them up in a prison. They should go to hospital. Even in hospital, they can be under detention. Now, it is the duty of those of us who are in these positions to assure these officers of ours that, look, as long as you are acting within the law, you'll be protected. There is a lot of fear. I can imagine, for instance, in the case of Eddie Mutwe, I think the prison officer who received him perhaps knew what to do, but he must have been terrified. What will happen to me? Instead of asking what will happen to Eddie Mutwe if I lock him up in this condition, instead he asks what will happen to me. And that's a question that all of us should ask. When I'm faced with a situation where the constitution is being abused or the law is being abused, I could ask what will happen to me. My job as Minister of Justice, my position, my salary, and so on. But really the right question should be, what will happen to these citizens who are supposed to be protected by the law? Now, for those who are Christians, you know that is the question that the Good Samaritan asked. Instead of asking, what will happen to me in this dangerous corner on this road to Jericho, he asked, what will happen to this person who has been robbed and beaten up so badly? Now, that is really the question we should ask. And it doesn't matter whether you are NRM, whether you are NUP, but the bigger question now also is, what will happen to Uganda? Because that question also, people try to avoid it. People want to start fires, people want to issue. Is everybody in the judicial robe is a member of Uganda Law Society. They actually they have IDs of Uganda Law Society. They are members of the bar first, because without a bar, there's no bench. So I want to put it on record that the standoff between the Uganda Law Society and the judiciary is undermining the enjoyment of rights in Uganda. It is undermining the normal functioning of our justice system, because it is poisoning the relationship. We need mutual respect. I want also to put on record that I have talked to the Chief Justice on this matter. I have talked to the retired Deputy Chief Justice, who I have asked to be part of mediating this conflict. I have talked to the Attorney General about this matter, and I do believe that the dispute or the conflict between the bar and the bench is now ripe for resolution. There was a time when it was not yet ripe for resolution. Everybody wanted to prove something. But the Chief Justice is retiring in a few months. I do not think he wants to retire when, as head of the judiciary, he is at war with the bar. And then I think the bench also need to realize that they cannot use their judicial gavel to paralyze the normal functioning of the Uganda Law Society. For instance, now the Law Society has not elected their members to the Judicial Service Commission. It's a scandal. The lawyers are grumbling in the corridors about how judges are being appointed and so on. They need to be there in the new Judicial Service Commission so that they can speak about the issues that they believe can improve the appointment of the best possible judicial officers. That said, I remain optimistic as Minister of Justice and Constitutional Affairs, provided we put our country first and we don't look primarily at grandstanding. In this country, there is space for doing bad things, and there are many people who are occupying that space. We may not actually have the power to stop them, and I don't even think it is useful employment of our time to even try to stop them. But there's also space for doing good things. I call upon those who are committed to doing good things to spend their time occupying the space of doing good things in this country, and they will be happier, because there are many people, both opponents of the government and supporters of the government, who are busy doing some bad things: corruption, murders, tortures, abuse of human rights, and so on. They have occupied that space. The rest of us, let us occupy the space of promoting healing in this country, of doing something like this, where you host an open conversation and people tell each other off, as I'm sure I'm going to be told off very soon, so that I go back and become a better minister. Thank you very much.
Thank you very much, Honorable Norbert Mao, Minister of Justice. Thank you very much, Honorable Norbert Mao, Minister of Justice and Constitutional Affairs. If you're just joining us, we are on our Judicial Service Conversations, hosting the Minister of Justice and Constitutional Affairs, the Honorable Norbert Mao. He has just taken us through the state of justice in Uganda, and he has told us about how there are many things. He has dealt broadly and strongly on a number of topics, and I'm sure there are going to be a number of questions coming from colleagues and compatriots. Honorable Minister has talked about a master's in dispute resolution, and I think there are a number of disputes that need masterly resolution. So maybe I'll start with Alfred, giving you the first question, Alfred Muyaka, and then the next question will come from Mercy Makabai after you answer Alfred's question. Over to you, Alfred.
Thank you, Minister. I think you used almost 40 minutes to give the state of the nation as a whole, and even now the state of the bar and the judiciary. And so my takeaways were at that point that we need to work with members of the bar to spearhead several things from the state, especially with ADR. And I think regarding ADR, for many things, the appropriate dispute resolution, not even the alternative one. When we are talking about the state of the bar and the judiciary, my only point was on the president of the bar is now almost in exile because of the judiciary. And it's about spending his whole term of presidency in exile. So my question is, what do you think led to this impasse? Because even from the point he didn't speak at the annual law when you were happening, the lawyer, and the month later there are very many warrants against him, is now in exile, and you said all these conflicts are ripe for resolution. So what do you think led to that impasse of having him now almost in exile because of the judiciary, and how can we resolve it faster? And he comes back and serves the members of ULS from Uganda. Thank you, Minister.
Well, Ellison, I was there at the opening of the annual law year, and I actually didn't know that the Chief Justice had directed that the President of the Law Society should not speak. So in my utter ignorance, I tried some shuttle diplomacy. Normally, the President of the Law Society has a slot to speak. And we must accept that leadership is a continuum. In school we learned about the number line, and all leaders fall somewhere along that number line, and President Semakade of the Law Society also has where he falls on the number line, and I think any society must make room for that. So I called the senior technical advisor of the judiciary, who is now Justice Hauka, and we went out and I asked him, why is the President of the Law Society not on the program? And he said, I think he has been removed. So I wrote a note to the Chief Justice, and to ensure that I don't give it to anybody who may fear to take the note, I took it myself and gave it to him. I had then made a proposal that since the President of the Law Society is already there, and I'd even requested for a copy of his speech, and I'd seen it, and he was speaking like Semakade would speak, and I think nobody would be surprised by what he would say. He was denouncing corruption, denouncing the slow pace of justice, and of course talking about the many D's of the radical bar, which I think can be absorbed by an audience of learned people. It is not like the skies would fall if he spoke. It is sort of like those days when we had Northcote. You know, whenever the president would come to Makerere, we knew that immediately after the Ugandan anthem, Northcote anthem would be sung, with or without the permission of the MC. and we just factored it in, rather than making it a big deal. And immediately after the Northcote anthem, they would drum. They would then claim that they welcome the president of the neighboring state of Uganda, and that the Northcote state will guarantee his security and things like that. It all took about 5 minutes. So I then proposed that since the law students had brought an award, actually all the law students in Uganda came with an award for the Chief Justice. Apparently, I didn't know how excited the country was about the ruling on the court martial. So these people had actually elevated the Chief Justice to a massive podium. And then I proposed that the President of the Law Society should come and introduce this award. That was the only way I could see the President of the Law Society having some airtime. Now, that was totally rejected, and later the Chief Justice gave his reasons. It was not a good occasion. We were only lucky that the members of the bar did not walk away with the president. It would have been very, very embarrassing. So that is exactly what happened. I know there are a number of judges who feel that really the relationship should be improved. Now, I want to tell the lawyers that I don't think this is personal between the Chief Justice and the President of the Law Society. You must know that this is not the first time the Chief Justice has crossed swords with a third party. Remember when the Prime Minister stormed the magistrate's court in Mengo, and even occupied the magistrate's chair, and she was swinging on the chair it was the duty of the Chief Justice to step forward and, you know, draw a firm line and say, you know what, please respect the courts. Now, we have also had the Chief Justice clashing with the executive on the question of bail. I witnessed an occasion when the president gave a speech and said, you know, I don't want bail for this kind of offenses. Why are you ignoring victims? Then the Chief Justice stands up and say, you know, please, my fellow judicial officers, continue giving bail according to the law. So we must not take this out of context. I think what makes this different is the kind of language that the president of the Law Society uses, which, according to my research, is called radical rudeness. So, the president of the Law Society uses what is called radical rudeness. In other words, using obscenity and insults as part of his arsenal of fighting for change. But remember, we are dealing with people who are high-ranking, and they have their own opinions of what they mean to the society. As Norbert Mao, I really don't mind what you call me. First of all, I am also capable of radical rudeness. I can also say it in spades. For every spoon you throw at me, I'll give you a full wheelbarrow. So that way we are square. But the Chief Justice is not likely to do that. So I think the president of the Law Society should reserve the radical rudeness for certain people and not necessarily for everybody, as a way of de-escalating the situation. Fortunately, that incident, I don't think, made anybody happy. Nobody was happy, even though the Chief Justice owned the decision. But within the judiciary, many people felt like, you know, there are some things which are like courtesies. That's why even when there are war in Ukraine, when you have Libya under attack, the ambassador of Libya still has airtime in the UN. There are some courtesies that have got to be accepted, and it's a difficult thing, but I don't want to say too much about it because there are many things we are doing in the back room. I only want to press the members of the Law Society that is our duty to ensure that the members of the Law Society don't become a victim of this fight. The institution has got to be protected against all odds.
Thank you very much, Honorable Minister. If you're just joining us on these Judicial Service Conversations, we are joined by the Honorable Minister, the Honorable Norbert Mao, the Minister of Justice and Constitutional Affairs. He's answering everything and anything justice and the state of justice in Uganda. And on that issue of radical rudeness, of course, Honorable Minister, just before Mercy comes in, one of the challenges that some members of the Law Society have is that their lordships struck down the laws of sedition, the laws you know, they said you can use offensive language against the parliament. They struck down the Offensive Communication Act. They struck down all these laws, but members of the society are saying, have they made a law for themselves called contempt that brings back offensive communication, criminal defamation, sedition? But maybe we shall deal with that debate later on. But that's one of the challenges members are having. They're saying, my lords, you're the ones who removed these laws. So, but Mercy Makabai, maybe before the minister takes on that, maybe Mercy Makabai, you could throw a question in.
Yeah, thank you very much, Ellison. Honorable, I think you've been very elaborate on this issue of the impasse between the judiciary and the bar. And for any lawyer listening in the audience, we have other challenges that have been a ripple effect of this impasse. For instance, we have no representatives at the Judicial Service Commission, as you have already highlighted. We have people losing faith in the ability of the ULS to stand independently and make decisions and have representation and actually own those opinions in different spaces. My question is, what do you think are the next maybe 5, 1, 2, 3, 4, 5 steps that need to be taken for this issue to be solved in maybe 2-3 months? Because it has taken over 6 months of the president's time as a president, but also it has affected the ULS and the people at the bar and just how things are running. So I would just like to understand what you think are the next steps to have this issue solved in 2 months, for instance.
Well, Ellison, let me start with what you said. The truth is, ironically, this fight is part of the decolonization agenda of the radical bar. This is really the biggest irony of the whole thing. the Uganda Law Society elected a person who stated clearly the kind of president he was going to be. Semakade never hid anything. I think even if he had said, I'm going to slap the Chief Justice, vote for me, and people would still vote for him and say, okay, now please go ahead and do it. He said that veneer of decorum is a shield behind which a lot of injustice hides. That's what I followed your campaigns, by the way. Contrary to what you people think, I'm around. I heard him blasting some of the people who were saying he's not a gentleman. He told them off. He called those ladies stiletto lawyers and so on and so forth. So I think it is up to the membership of the society to draw the boundaries of what this decolonization means. It starts with how the president of the Law Society dresses. He wears these Rambo boots with a trench coat, and in 24 hours he has like 5 hairstyles. He can have cornrows, he can have dreadlocks, he can have whatever. He is generally presenting some kind of image of himself. Then he calls his followers rebels. In other words, the members of the Law Society voted for a non-conformist. So they wanted a non-conformist. Unfortunately, a revolutionary approach to our conservative judiciary is not going to work. We actually need to reform it gradually, and I think it can be done. It is possible to reform it. Ask me, at the age of 26, I stormed Gulu. I wanted to be a member of the Constituent Assembly. I come from a very conservative society. A man who was 80 years old, who never even printed posters, beat us hands down because he said the Constituent Assembly is not for children. and my fellow youth, many of them believed in him. So in the same way, the rebels need to rethink their strategy of achieving their goal. Now, to Mercy's question, the steps. My first recommendation is, of course, to identify bridge builders. I know, for instance, Ellison is a bridge builder. He uses hard language, he is part of the rebels and so on, but somehow he can go and talk to anybody. The vice president has actually held the fort quite well amidst all these situations, keeping the agenda of the society alive. So the Law Society needs to identify bridge builders. Then the judiciary also need to identify bridge builders. I have already spoken about the retired Deputy Chief Justice. He can be a bridge builder. I don't know after this Twitter space whether I will still be a bridge builder on account of my statements about some of the colonial tendencies that the Uganda Law Society wants to demolish. But I am here. I'm the minister in charge of amending those laws. If you really want to amend those laws, if you want to sack the Attorney General and the Solicitor General, you have to do it through Parliament. If you sit in your meeting and you will be like the day I convened the General Assembly of Makerere Student Guild and dismissed the Vice Chancellor. We are actually on record. We even signed a letter dismissing him. It was signed by Dr. Henry Honoria, and it was a concurrent resolution of the Guild Representative Council and the General Assembly. Of course, the Vice Chancellor never left. He never went anywhere. It was only for our own happiness. So I do believe that there is need to go back to the fundamentals. Incidentally, the Law Society is being dragged into the arena of the national issues. Now, it's not my place to tell the Law Society what they should do and what they should not do. In Kenya, the Law Society of Kenya was a very big player in the kind of reforms that had to be done to democratize Kenya to a certain extent, the demands for a new constitution, and that requires that the Law Society can set an agenda for the nation. And for me, I can tell you that I have no problem with that. I think that is legitimate. But now the issue of insulting judges and calling them names, insulting the DPP, talking about her unmentionables, I think those are the things that pushes the Law Society away from, in a society where the politicians are seen as corrupt, compromised, and so on. There's actually a low-hanging fruit for the Uganda Law Society to become a champion of these issues of the nation. You remember the Nairobi Law Monthly, published by Gitobu Imanyara, was like the kind of pamphlets of Thomas Paine in revolutionary America. It is the one which acted like a kind of step-down transformer for the difficult issues, for the ordinary people. It was a best-selling magazine. Everybody who wanted to know why a one-party state is bad and a multi-party state is better counted on the Law Society to do that. And I think, even without talking too much about reconciliation, if the Law Society sets a new agenda and starts talking about these issues like transition, start talking about national dialogue, the need for a national conference to talk about Ugandan issues, about reconciliation, which you can already hear the president publicly making apologies, the Law Society can become an agenda-setting organization, and that will then give it a new image, because for now the radical bar is perceived as dominated by foul-mouthed people who specialize in only insults and so on. And yet, ideally, the Law Society has got a lot of issues to talk about. For instance, the laws that come to Parliament. We need the Law Society to appear before these committees, and right now we are going into elections. We need that, and together with the law schools, they can give feedback on the judgments. That is why universities have law journals, because when judges are reading their judgment, they must be terrified of the opinions of professors on their judgments. Right now, even in America, the Natty Dread case, I'm sure the judges who made that judgment are still crying over the stupid judgment they made, denying a slave who had escaped a slave territory the right to freedom by saying a slave is not a citizen of the United States and therefore cannot enjoy the rights of a citizen. So when it is the only warning to judges that, you know, you make a silly decision, we will hang it around your neck for the rest of your life. Even your great grandchildren will still read about it. So the Law Society can start setting a new agenda, and I think there's still opportunity for that. That is number 2. And then the last one is, of course, to mend fences with the seniors. The rebellion was against the senior lawyers who are seen as the conformist, comfortable lawyers with, you know, leather seats in their chambers and so on, while the other lawyers are having, you know, plastic chairs and in their law firms, they are on borders and so on. Those are really the rebels. And now it is important to get back to some of the old guards and use them as bridge builders. That to me is number 3. And number 4 is now me. I have not had a chance to speak to the Law Society president, but I do believe that there is no reason why he cannot return to Uganda. I can tell you, it doesn't help the government to put Semakade in jail. I would advise against it. Occasionally we have such things. One time, yes, my president of the Law Society, if you are hearing me, please come back home. I will come to the airport personally to receive you. I want you to come back. Occasionally I get calls from people. One day some people were threatening to arrest Jimmy Spire. Now, Jimmy Spire is a cartoonist. He was my supervisor for my master's degree. He supervised my research. I think he has published very many offensive cartoons about me. That has not stopped me from greeting him when I meet him, because he's supposed to exaggerate every stupid thing I do. That's the role of a cartoonist. You do something little, he makes a mountain out of it. So somebody wanted to have him arrested. So we spoke on phone. And we know the people who sometimes have those ideas of arresting people. So we tell them that, what is the point? And in any case, if you arrest somebody, please hurry up, take them to court, bring the evidence and have them convicted. I think I would love that kind of action. And there are countries that do that. But in Uganda, arrest sometimes is used as a way of punishing you before trying you. And I would strongly oppose that. So I want to tell the members of the Law Society that you are the best defenders of the Law Society president. And if you make it clear that, you know what, let's fight legally in court. The matter is in court. You cannot arrest me on account of this and that. And also contempt laws, for those who were talking about it, should not be used, or rather abused. The contempt laws are for, like this man Arinaitwe, who wanted to strangle a judge. That is the height of contempt of court.
You got a less punishment.
Yes, he wanted to punish the judge. I do believe that we should note that the judiciary in Uganda had actually not been known for resorting to the contempt procedures. I don't know how many cases we have in Uganda. I don't even think they reach 10. And so it should be a last resort. I think we can guarantee that the president of the Law Society will not be subjected to an arrest. In any case, the warrant has been suspended for the time being, and nobody should be spreading fears to him. I do not think it doesn't serve Uganda well to have a president of the Law Society in semi-exile.
Thank you very much. If you're just joining us, we've been joined and having a fascinating conversation with the Minister of Justice and Constitutional Affairs, the Honorable Norbert Mao. I'm honorable on that last one. I think there is actually what was stayed was a warrant, but I think there's another order which I think is being appealed. And I think some of the concerns some members have is that it takes about 3 days to hear contempt and 6 months to hear a stay of execution. So there's a worry that the judiciary was weaponized. But on the larger point of what the Law Society should do, I can see on the call Mr. Lule Alexander, and last week we had Mr. Lule here, and he is the head of the Law Society or the bar in Masaka. And we have a challenge in Masaka right now. The lawyers practicing in Masaka have put down their tools. They have put down their tools because it takes they have one judge in Greater Masaka, which are about I think 12 districts, which are almost the size of Rwanda. And they have a single judge, and this single judge has currently a docket of 4,290 cases, which if she listened to and disposed of 5 cases a day, their calculation is that it will take her 22 years to finish the backlog. So they have put down their tools, and the question I think which they are asking, and as Minister of Justice, they're really asking for some form of a solution for Masaka. How can Masaka be helped? What immediate term solutions can be done, and can the government have some form of dialogue with the Masaka lawyers, if it's possible for the team, Mr. Sechewa, Mr. Chichoncho, Mr. Lule, and the number of lawyers who practice in Masaka, if it's possible for you to open your doors for them. I think that there was a request that we should ask you if it's possible to arrange and they actually meet with you and present their concerns, because it is for them a livelihood issue. It's also a justice issue that's affecting many people. So I think those are 2 concerns. I think the first one on the president, I think many members of the society will take that very happily. We completely agree with you that there is no need for the acrimony, but also there's a concern of the weaponization of the court to settle scores, and some people are very worried about that. But also fundamentally the issue in Masaka as well, because Masaka is a city. It's a massive industrial place. It's maybe not industrial, but it's a big business hub in this country. It has a massive population, millions of people in Greater Masaka, and one judge. So I think the concern is what can be done, and how can the Ministry of Justice help to resolve this standoff.
This question of Masaka starts with the deployment of judges. In one of my speeches at a gathering, I stated that we should have senior judicial officers posted up country. To the best of my information, the senior resident judge is away on study leave and has not been replaced, and the judge who is currently in charge of the station is a newly recruited acting judge of the High Court, I think she's one of those who was recruited in the last recruitment. So the lawyers in Masaka are right to complain. Now this should be something to be owned by the entire Uganda Law Society. It should actually be a cause for the national bar, not just the Masaka bar. Now that they have laid down their tools, we have got to discuss the context of these backlogs. The statistics I have is, as of December 2024, the High Court had over 81,000 pending cases. Out of these 81,000 cases, 27,000 are classified as backlog. That means they have been gathering dust for more than 2 years. Now, nationally, the statistics are that there were over 163,000 pending cases, and out of these, 40,000 plus are considered backlog, again meaning unresolved for over 2 years. The judicial officers are only 655. This delay in justice is the reason we are having this space, because everywhere citizens are grumbling. I was in Gulu yesterday, where there's a pre-bargaining camp. Many people go to pre-bargaining because it is a kind of last resort. Somebody says, you know what, let me get this over with. Let me know that I'm serving my sentence, rather than just waiting for a trial that may not come in 5 years, 10 years. So,
if I can interrupt you there, for many people, the plea-bargaining system has become the criminal justice system holding hostages. They do hostage taking. They hold you until you agree to a sentence, and that's one of the concerns. So what you're seeing in Gulu is really a replica of everywhere.
There are many good things to say about plea-bargaining. In 1995, I had the chance to attend a course in the University of Vermont, together with the former president of Zambia, now the late President Edgar Lungu. We went there to study what they call the public defender system. Now, an abuse of something is not an argument against its proper use. So even if plea-bargaining may be abused, that's not an argument against the proper use of plea-bargaining. I would still argue for plea-bargaining any day. But now, in the context of these backlogs and the wheels of justice being very slow, it can become prone to abuse. It almost becomes like a justice at gunpoint. You are basically being told, it's up to you. Either you accept or you rot in jail, as they say. So the Masaka Bar has a cause, and I want to promise the Masaka Bar that I will engage with the judiciary. It is not my job to tell the judiciary what to do, but I'm the microphone for the judiciary. I'm the one who speak out when judges are attacked by parliament and so on. It's my duty to say, you know, you are misunderstanding. This is what is happening. In the cabinet, it's our duty to defend the budget of the judiciary, and so on and so forth. So we have the opportunity to engage with the leadership of the judiciary, and the purpose is not really to serve the lawyers. The purpose is that they should serve the people. In any case, under the Constitution of Uganda, justice is served in the interest of the people. So nobody should feel that if the judiciary responds, then they are responding to the lawyers. The lawyers are doing their best to respond to pressure from the people who are their clients. And now they have transmitted that high voltage current to the judiciary by saying, you know what, there will be no business in Masaka courts. As of today, the Masaka courts are actually very quiet. Nothing is happening there, which is a sad thing, because you have Masaka courts moving from Kalangala, Sembabule, Lyantonde, Kalungu, Bukoma, Nsimbi, up to these parts here. About 12 districts if you include Masaka city. There are options. The Law Society has previously recommended pathways for acting judges. It is actually possible to bring in, let me call them special forces, for judicial special forces, for lack of a better word. They come in to assist. Now you find that Ugandans are being taken to support judiciaries in foreign countries to deal with backlog in Seychelles and other countries, but we are not in a position to bring in judges. So we will recommend that the Chief Justice should consider appointing temporary judges to deal with these cases. And according to the brief I got from the Law Society, they have been engaging with the people from South Africa, UK, Botswana, India, where there is a routine appointment of senior practitioners. In Uganda, we seem to be obsessed with appointing retired judges only as temporary judges to come in. But I think there are senior lawyers who can be appointed to dispose of these cases. So the concept that the Law Society of Uganda is proposing is called mission-based judges.
Yes.
In other words, they have very clear-cut terms of reference. If we can call judges to come and chair commissions of inquiry, why can't we get senior lawyers also to go to the judiciary to also help the judiciary with their problems? Because once in a while we got Justice Bamugemerere. We told her our land matters are in a mess. Come and tell us what we look like to the public. She came, and when her mission was done, she went away. We have had many other justices dealing with problems in the police, for instance. So why can't we have senior lawyers also go to help the judiciary? The reason why this matter is important is that it is causing a constitutional crisis. We are actually breaking our promise to the people, to the citizens, because the non-derogable right to a fair trial includes speedy trial. A trial which is too slow cannot be said to be fair. This is not a new idea. According to the brief from the Law Society, former Principal Judge Bamwine proposed this idea over 10 years ago, but it has not picked up. But it is important that if we want to reduce backlog, we are better off getting these senior lawyers. More importantly, these senior lawyers will go to the hard to reach places. Actually, the backlog is one of the arguments being used for court martial. Those who are advocating for court martial say that, you know, we want quick justice because the civilian courts are too slow. We have heard the president argue that the way to deal with cases like the cattle rustlers of Karamoja is through the court martial because they are faster. Now, if we deal with backlog, then we will answer that argument. In fact, the idea of a court martial for these kind of cases is almost a vote of no confidence in our civilian judicial system. So I hope that the Masaka leaders, the leaders of the Masaka bar, can find some time and we talk. I want to promise the leaders of the Masaka bar that let's meet in the course of this week. I want to hear what your proposals are, and I'm happy to go with you together with the national leaders of the Law Society, and we meet with the leadership of the judiciary, because the Constitution makes a promise to the citizens, and if the courts are closed, then that promise is being breached. I think we have got to apologize to the people of Masaka. There is no other way. We are very sorry that this is happening, because now Masaka is being treated like it is too far away, yet it is just 90 minutes away from Kampala. So let's meet and see a way forward.
Thank you, Honorable. Honorable, thank you so much. I think what you've said has been music to the ears of many of us. Right here in these judicial service conversations, we have been the strongest promoters of mission-based judges, based around Article 142(2) of the Constitution, which says that when the state of the business of the court so requires, the President may, on the advice of the Judicial Service Commission, appoint anyone qualified to act as a judge on a temporary basis. And we've been saying the state of the business of the court so requires. We've been saying this actually for 6 months before we saw what we saw in Masaka. And so I think your endorsement of this idea, and your ringing endorsement, is very strong. We've also hosted people here from South Africa. Actually, we've had Senior Counsel Moses Kahane, who represented President Mandela, President Zuma, Julius Malema, Floyd Shimbavu, and he told us here that he's an acting judge. He acts, and he told us what it adds to his practice and what it adds to the community, and he's a practicing advocate. We hosted here someone, I think, from Judges Matter. So we're very grateful to you, Honorable, that you've picked out on this. We're also very grateful that you've agreed to find time to meet the lawyers in Masaka, and also that you've also agreed to address the issues concerning the liberty of the President of the ULS. I think maybe Mercy will take us to the next question.
Yes, I think, Honorable, I want to really extend my gratitude, because the way you've addressed the issues of Masaka, it's very interesting to see that after the conversations we've had over 6 months, we actually have a result, and we really want to thank you very much for that. We also want to thank you for the endorsement on the issue of mission-based judges. My question to you is with respect to consultation of lawyers when it comes to passing of some of these laws. We've recently had the Succession Act amended, and we did see that letters of administration were lapsing by 31st of May 2025, and we hosted here a number of lawyers who discussed and tried to explain to the public the impact of this law. But many lawyers expressed their concern that they were not consulted prior, and what this resulted into was impractical laws. Because if you have letters of administration lapsing on 31st of May 2025, and you have a number of people who have been running estates for over 10 years, and they're not aware of this, or the idea of how it's actually being implemented leads to an increased case backlog, because you have people applying for extension of letters of administration, applying for extension of time within which to file their inventories. So you end up having a double challenge. And yet this is a law that was passed by Parliament, and the people who actually affected were not consulted, I think, in great detail. And this is replicated in a number of other laws. In your opinion, do you think that the lawmakers are taking enough time to consult lawyers and the rest of the community before they pass some of these laws? Thank you.
In other words, is there a regulatory impact assessment?
Well, I need to share with you my own experience in government. As you know, I only joined government in 2022, and I'm still learning. One thing I found in government is what I would call territorialism. So one of the biggest challenges that sometimes we don't act like one country. We have got to accept that all these entities are part of our body politic. Whether we think they are nasty, whether we think they are a nuisance, they are part of the ecosystem. Uganda really is our Noah's Ark. You know, in Noah's Ark, you have the cats, but they are restrained from attacking the rats because, you know, outside there is a storm. So every animal has to be at peace. If we could adopt that attitude, and we know that this Uganda is our Noah's Ark, and there's no one out there who is worried about the development of Uganda. Some people think the British will come and make Uganda better and democratic. Some people think Donald Trump is losing sleep over our problems. Some people think, you know, the Scandinavians care about Uganda. We have to accept that really we are inside our Noah's Ark, and out there is this storm, whether it is Iran, whether it is this and that. If we could have that attitude, I think we would have a better country. So territorialism is the reason why nobody wants to involve other people in order to improve their decision making. At school, I learned what they call the decision making matrix. First, there is the person who recommends a course of action. And I would like to challenge the Uganda Law Society to be more proactive. A decision maker is powerful, but somebody who recommends a course of action which ends up into a decision or leads to a decision is equally powerful. Sometimes, even if you are president of a country, you may stand up and announce that I have decided to do this, but it may not even be your idea. But because you are the president, you have the D, namely the decision-making power. But there are those who have the R, the power to recommend. I think the Uganda Law Society needs to step up to the plate and exercise its power to make constructive recommendations about what needs to be done. Then there are two other steps. There are those who need to agree. Now, if you are making a decision or passing a law which is going to affect very many citizens who are represented by lawyers, it is important that the Law Society gives it a nod and says, we really agree. It's not a bad thing. But more importantly is that we must have an inbuilt system of seeking the input of the Uganda Law Society when we have some of these laws. And that brings me to my own docket. You know that we have developed a final draft of the National Action Plan on Human Rights, which is a voluntary undertaking we made as a country, even before I joined the government. So the team at the Attorney General's chambers has been burning the midnight oil for years. And one time, even President Biden took to the podium to blast us, saying Uganda has not yet honored its commitment to come up with a national action plan for human rights. I wish to inform everybody that the plan is now ready, and now I need to practice what I'm preaching here, because I realized that I have not officially sent a copy to the Law Society for comments. So let me lead by example by ensuring that tomorrow we send a copy of the final draft of the National Action Plan on Human Rights and request the Law Society to comment. I think many times we are more interested in the opinion of the so-called donors rather than the opinion of our citizens, who are really the Law Society. For the donors, they will always keep moving from one country to another, but the Law Society is here to stay. They are our citizens. So I make those recommendations that the Law Society should be proactive, and where the government is not thinking quickly enough, make your recommendations. We will either say yes or no, but at least we will know that there is an idea that we should consider. And then secondly, there are matters where you need to say yes. It is important. We are right now coming up with the proposals on LDC. The Attorney General presented the bill turning the Law Development Center into an examination center rather than a teaching center. That is a revolutionary piece of legislation. I think it is up to the Law Society now to send their comments as quickly as possible. But even without that, we will have to invite your input in this law. Of course, the power to decide is largely for the executive, headed by the president, because it is the president who has the mandate based on the elections. Now, he cannot cede that power to decide, but the quality of his decision will be improved immensely if he gets enlightened input and if he gets recommendations from those who are experts. So the executive will always seek to retain the power to decide, and I'm a very strong advocate of holding on to that power. Many times you elect a president, then the president surrenders his powers to civil servants who terrorize citizens, and then everybody is complaining to the president, please come and intervene, we are being disturbed by this. So I believe that we have to pick up these lessons. About Parliament, I also think one day you will have to host Madam Speaker on this X space. If you send me as an emissary, I will tell her that Madam Speaker, my feathers were plucked, and I have come to inform you that you are required to appear and talk about whether you are really making the best use of this Law Society. It is a resource. Why would we think the Uganda Law Society is a burden? It is like the public servants we have. I consider myself extremely blessed that I lead a ministry of more than 90% legal professionals. There are hundreds of them. They are at my disposal. Any question I want answered, I just tap a code on my phone and I will get an answer. Even if I want a copy of the Constitution of Tuvalu, very small country there in the Pacific Islands, within 10 minutes somebody is in that building to bring me a copy of that Constitution. So as decision makers, we disempower ourselves. So even as a nation, we are the losers if we don't use the resource that the Uganda Law Society presents. This is the only time that I hear a resource asking, why are you not using us? You know, you are in Parliament. Why are you passing bad laws, yet we are around to help you to make better laws? It's really a scandal, in my opinion. I can tell you, even when I was LC5 chairman, I became the first LC5 chairman to demand that I should have a technical advisor. One day I had a meeting with the minister from the UK, I think Minister for International Development. He came with a huge delegation of more than 10 environmental advisor, conflict advisor, economic advisor, advisors on everything. And me, I was on my side with my poor cow, two of us, with this high voltage delegation. Now, what sort of discussion are we going to have? When we are talking about the role of Sudan in the conflict in the north, the minister gets a note from the expert. For me, I'm so disempowered. So I just became also radical and said, Honorable Minister, this is so unfair. Look at the kind of delegation you have and mine. Would you consider paying for a technical advisor for the office of the chairman of Gulu district? So he asked the person who was in charge here at the British High Commission, and they said, yes, we can do it. That's how we recruited Michael Tebere from Oxford to come and sit across my office. And I can say that is one of the reasons why Gulu district was able to overtake Wakiso for the first time in many, many years. So we cannot speak enough about the need to get quality advice from professionals who are willing. Why should Law Society be begging to help Parliament? But that lies with the Madam Speaker, and I'll pass your message.
Yeah, thank you, Mr. Honorable. You have promised justice to the lawyers in Masaka, as you are promising to help them come back to work. Even the young lawyers who are on the call who are like, they also need justice. That for them, their generation in limbo. Like they are suffering, not because they want money from the government, but because they are being denied the right to practice their profession. They are spending almost 3 years to be enrolled as advocates. So in a total now they count that they need 10 years to become advocates. 4 years in law school, 1 year for LDC, 3 years before they be enrolled as advocates. So it's coming like 10 years for them to be advocates, and they are looking towards you. What can be done for them, because their careers, they are being wounded by the system which is supposed to support them. Because of the enrollment, their careers are crippling, their lives are being affected, their mental health is, they are depressed, they are losing a lot of jobs because they can't be given jobs. When they apply for jobs, the first requirement is are you enrolled, and they keep missing out on that. They can't even practice as in private practice, even where they're working from in law firms, because they are like, you're not enrolled as an advocate, so you are more or less a clerk even after finishing all this and everything. So as we have offered solutions to people in the lawyers in Masaka, even these young lawyers who are in limbo because of late enrollment, they are looking forward to a solution from your hand, and maybe we will get it from this space. Thank you.
There is a traffic jam at the Law Council. That is a fact. We have to deal with the culture. There is a culture that needs to be tackled. I get a lot of complaints on my desk, and many times when we talk to the secretary of the Law Council, she to perform the full time somewhere else. So they really don't have the time to sit. I personally don't understand the formality and requirement for a certificate of eligibility. It is one area where the senior lawyers in the Law Society have to tell us what would be the ideal. It is causing a lot of frustration. Now, that said, we really would like to have on the roll lawyers who are ready to practice. I have had some encounters that have horrified me about whether some of the people we have on the roll are really ready. I do not know what the solution is, but the solution is not to cause a traffic jam. Now, we need a system that will take away those who are not ready as early as possible, so that they don't reach the stage of even applying to the Law Council. And that is why we have bad news that pre-entry is coming back. That's really the only way. We want to let everybody know that whether we like it or not, pre-entry is coming back. In some countries, law is a postgraduate course. You first have to do another course, then you go and you study law. Pre-entry is an objective test, just like before you do a master's degree, you do the aptitude test. The aptitude test is just a measure of your brain. They are not asking you any facts which you can cram. They just test your ability to think logically and to reach conclusions that are sound. So I'm a supporter of the pre-entry. 2 weeks ago, the Attorney General presented that law, creating the LDC now as an examination center. But we have got a decision to make whether we want to increase the numbers of those who make the decision, so that we have many panels that can make the decisions in the Law Council, or we eliminate it altogether. I don't have the answer right now, but if we have done all the quality assurance, if we have front-loaded all the quality assurance, then I don't see why somebody should start going through all these steps. Certificate of eligibility, you gazette, then you do this and that. I think the new system is going to come with some positive changes. I propose that you let us share with you the bill, because got a green light on what should be done. I personally believe that this is a problem which is legitimate, but at the same time, the thousands and thousands who are applying, I also, even from ministers, as you know, many of them have gone back to law school also, so they are also facing those challenges. I want to suggest that you wait when this bill is published, then you eliminate the certificate of eligibility. I don't think it exists. The 3 bans have been read. I don't think the church first gives you a certificate of eligibility to marry, but still powerful. So they have to sit at a particular time in the day to approve who should receive their savings. It is your money. Now you go to the bank, the bank even money to any corner of the globe, with the possible exception of Russia, where unless you have a card known as Union Pay, you may starve. So the colonial legislation that we have were intended to give a sense of power to bureaucrats. Technology now should be able to democratize this. I look forward to the day when all these processes will be done online, like URSB. A lawyer should be able to fill all these things online, and everything should be online. And then when their lordships or whoever makes those decisions at the Law Council, they should be able to get these things and act. We are doing it at the Ministry of Justice, by the way. There's an electronic filing system. I mean a document system. They have e-docs. Every document is now electronic, and it really harasses everybody in Attorney General's chambers. And it even has a color code. It is green if you are still within the deadline. The moment you are being warned, you see it turns to amber. When it is red, it means now you are out of time, and it keeps warning you. And that's why the AG's chambers has become a lot more efficient in churning out legal opinions and comments even on government contracts because of that system. I've refused to sign on it because I'm old school, and I'm political, so I have a good excuse. So one of the recommendations that I would put in the Law Council is that we make sure most of these things are done online, the way it is. Those days you would print memorandum and articles of association, you go and bind them, then you look for those people in the Ministry of Justice, they stamp it manually. If the person with the stamp is not around, you have to wait. Registering a company would take weeks. So we can use technology also to eliminate this. I believe those are options. In other words, we are open to suggestions from the Law Society.
Thank you. Thank you, Honorable Norbert Mao, Minister of Justice and Constitutional Affairs. If you're joining us, we've been here since 7 p.m. speaking all things law and all things justice with the Minister of Justice and Constitutional Affairs. I have maybe before Mercy comes in, I have two quick announcements, Honorable. The first one is I have seen that we have been joined by the Vice President of the Uganda Law Society, and I think we'll be giving him an opportunity to ask or make a comment on what's happening. I have also received a message from the Masaka Bar that is very grateful, and the words they are saying is they are most obliged for your words and for being able to come out and apologize for the situation and for taking their concerns seriously. They are very happy to meet with you, and they will ask that we communicate to you that once they have a date and time, they prefer tomorrow. So they are saying they can they can come to Kampala and engage on this. But as we're getting the Vice President on, I think Mercy also had a question. Please, if you have questions, we're about to wind up. I think we'll be winding up in the next 20 minutes. We'll be winding up in the next 20 minutes. So please, if you have any questions or comments, kindly send them through to us so we can put them to the Minister. And maybe we'll have Mercy, and then I don't know if the Vice President has come on yet.
Yeah,
and then we'll have the Vice President. Mercy?
Thank you, Ellison. I think it would be a disservice for us to close the space without making a case for a number of lawyers who we hosted here who represent a diverse group of people. I would say women, a number of marginalized groups of people. And in doing so, we did hear a number of experiences that they're having when they represent people who don't have maybe finances to access lawyers who would represent them in courts. And that means that they have no representation, or they rely on these organizations to give them access to a lawyer who would represent them. Or we have people who don't even know their rights. We have people who are in prisons for a number of years on remand with no access to a lawyer. You mentioned, Honorable, that the Ministry of Justice is working on an HR, human rights paper, and that you're going to share the same a policy that you're going to share with the Uganda Law Society. And you also mentioned that there's a desk within the Ministry of Justice that deals with these questions that many people have. Our worry is that the challenges that they presented before us may need more action if we're going to meet people's needs as of now. What other steps is the Ministry of Justice taking to be able to access these marginalized groups of people all over the country, but also increase access to justice and to representation for these people? Thank you.
from where I sit, I ask myself whether the things I learned in school are really the most relevant to the job I do. If I sample the people who come to see me, let me talk about today. Number one, somebody has a piece of land at the equator. All of a sudden, somebody has acquired a title over his land and has even sold part of it, and the person who has illegally bought the land is now threatening them. So the vast cases of injustices actually have very little to do with the courts. I don't think it is even fair to make the question of injustices in Uganda about the judiciary. In any case, only slightly above 10% of the cases and disputes go to the judicial system. So that one was live in my office today. It is ideally, I don't think there's any minister of justice in any country like America or Britain who people go to see over maybe a piece of land somewhere in London that somebody has forged the title over. That tells you that we really have serious problems. We have a brokenness in our systems. Imagine if you woke up tomorrow and your records at NIRA have changed and you are no longer Ellison. If it were possible for somebody to go and change your particulars, they change your date of birth, they change, they say you have blue eyes and things like that. This is that's one case. The second case, a mob justice. Some people carry out mob justice, which in itself is a symptom of a problem where people don't trust the police. They think that if you don't beat up the thief quickly, they will get bond after paying a bribe. Before you reach home, the thief will have arrived back home to wait for you and taunt you. So, Minister of Justice, these people have been in jail for 3 years, no trial. In one case, after bugging the DPP, a nolle was entered. That is a case number 2. Then you have cases of botched up compensations, citizens who are not being compensated in time. Another one is where somebody is being threatened with arrest, yet he is a witness in a criminal case. These are the injustices that we are talking about. In other words, can we give our citizens freedom from fear that our justice system is for them? The majority of Ugandans actually are law-abiding. Now we need to tackle that minority that enjoys the protection of the state, and they act with impunity. So as a result of that, the president has done some fire brigade measures. Those fire brigade measures are really like bandages of a bleeding wound. So he has land protection unit. They are there in Nakasero. But the moment they get into a case, they are likely to collide with a powerful person somewhere. And that will be the end of the investigations. When somebody says, do you know who you are playing with? Then you back off. The other fire brigade unit the president has put is the State House Investors Protection Unit, where Canon Nakalema is doing some work to protect investors. Here is a situation where an investor comes to Uganda. he is made to pay big money under the guise that he's going to get maybe some contract or to get land to build a factory. He is conned, he never gets the land. When he becomes agitated and wants to activate the justice system, then he's accused of defilement. Out of the blue, he has not even shaken hands with a Ugandan woman, but he's told that, you know, there's a complaint here that you have committed defilement. In no time, he's deported out of this country. These are the injustices that we deal with. I can tell you this confidently because this is my daily menu. Every day I have to deal with these cases of the injustices that people face. You have another situation that somebody is interdicted. Now, interdiction is supposed to last no more than 6 months. There are judicial officers who have been interdicted. So even judicial officers are facing injustice. A judicial officer is interdicted, and after the expiry of the 6 months, you would expect them to go back to office. But they go back to office, they tell them, no way. The Attorney General has written opinions telling the power interdiction cannot go offices. These are the injustices that we are talking about. So what does it require? It basically requires political will. And it means those who are in charge of supervising the officials should crack the whip. At the Ministry of Justice, our job is to ensure that those who are in charge of doing things do them in time. At least within the ministry, we have attempted to create a kind of ecosystem that endeavors to deliver, because we are really a service ministry. We serve everybody, including LC3s. When an LC3 wants to do a bylaw, they send it to the Ministry of Justice. We also serve them. But I want to make a strong case for actions outside the judiciary. And these actions is about citizens getting served by the government. If tomorrow you walk to any government department and demanded a service, chances are that you may get a letter, but you may not get a real solution. Finally, when we have a problem, such as the problems we have in, let's say, administration of estates, I want you to know that there are times I have gone to the Administrator General's office to mediate between families. Citizens are suffering. There's a lot of meddling with estates simply because sometimes the system has been corrupted. Then we still have cases of files disappearing, by the way, even in the judiciary. It is a big scandal. There is a case in Mbarara. It came to my desk today that the file disappears and appears according to the will of somebody. These are things that we have to talk about. As a result, people think that everything must now go to the president. So the president is burdened with so many things that even a clear-cut case, somebody says, we need to see the president. You do not know how many people come to me saying I should tell the president that they want to meet him. And I tell them, why are you taking away my job? The president gave me this job. Why don't you let me do it? There are very, very many cases like that. And sometimes we have been able to solve these problems at the Ministry of Justice. So it is not only, actually, injustice is not only at the Ministry of Justice. It is virtually everywhere. Now we have the pre-meds, the pre-medical students. That's another, you could say it is an elephant in the room. We have got to deal with that. And then the other day, some lawyers came and told me they want to set up a trade union. I don't know whether you are aware of it. Yes. I suspect they want to go to Parliament because they can easily produce a workers' MP. They are very serious, and they have some numbers. They have decided to register trade union of lawyers, and I asked them whether they have any links with the Law Society. Of course, they are members of the Law Society. So closing the justice loop requires very, very, very many people, to the extent that now I am carrying out consultations on the need to appoint justices of the peace all across the country to go and check on police posts and so on. Many of the people we think have disappeared. Some of them were dumped in up-country police stations, and some people don't know who even dumped them there. This is a reality. So the answer lies in transparency. The law has provisions for justices of the peace. Now we need particular kind of citizens who can assist the justice system, and people who can be trusted. If we can restore trust the way we are struggling to restore trust that courts are everywhere, we can tell you without any fear of contradiction, and I've talked to the Chief Justice, and the President also has committed to support it, that in the next 5 years there will be a magistrate in every constituency in Uganda. That definitely will ensure that at least people can have their disputes resolved. We are on track to ensuring that there is a high court in every district in Uganda. And then the Chief Justice has already set a date for groundbreaking for the 3 Court of Appeal circuits, Mbarara, Mbale, and Gulu. Hopefully that will help. We are having a big debate now on the Supreme Court. You lawyers are clogging our Supreme Court with the cases that I think have no room in the Supreme Court. There are some cases that have gone to the Supreme Court which have really no questions of law to be decided. The U.S. Supreme Court, I don't think they even handle 50 cases in a year. There must be very, very, very few. We faced this debate when the parliamentary committee threw away my proposal. I wanted the Supreme Court to be increased to 15 judges. I was chased away by Parliament. They said that is not their problem. But I'm now reconsidering it. Remember, those who go to the Supreme Court are of a particular age bracket, and constituting panels may be difficult. So I'm in consultation with the Chief Justice. Maybe we will go back to Parliament. So if we go back to Parliament and we get the number increased to 15, already the Court of Appeal, we are at 35. We can create the panels. Now some of the people will move from the Court of Appeal and go to the Supreme Court, and we still have room to recruit very many more, because the establishment of the High Court Parliament approved 151 high court judges, which is more than the number of districts we have in Uganda. So those are things which are on track, but the pressure points of injustice are not just around the judiciary. They are all over the place. In very, very, very many places we have got to deal with them.
Thank you, Honorable. I think if you're just joining us, we're about to wind up. We're with the Minister of Justice and Constitutional Affairs. Honorable, as you were telling those stories of what comes to you, I remember the famous case in one of our, not famous, but a notorious case in one of our courts here where somebody applied for letters of administration and the alleged deceased turned up in court and said, my lord, I am alive. And they asked him for his national ID. And he asked the judge, but can you ask the applicant to bring the corpse? Because so that sharp practice you're talking about, we've witnessed it. Of course, we're still looking for the vice president. I don't know, for some reason I couldn't get through to him. He was on, and then I don't know how he got off. Maybe if he could request to speak, then we could give him the microphone. I think many of the challenges for so many lawyers, for example, some of the challenges at the Supreme Court are that for many lawyers, they just haven't been heard for years. I think there are a number of matters in the Supreme Court that haven't been heard. The Court of Appeal has 12,000 cases. Right now, we had here a very senior lawyer who told us that he once filed a constitutional petition and then he forgot about it. He moved on with his life, and then about 12 years later he was given information that he had won his petition, and he asked, what did I petition about? so I think he was here, but if he's on the call here, maybe I'll not call him out, but he was here. So I think there are serious issues of backlog. We are just remaining with about 5 minutes to close, and we had comments from the vice president. We had also, I think, gotten a comment from the Masaka people. I think we had read that one out. I can't see the request, but if you're just joining us, thank you so much for the time you've been here. For those who have been here for since 7, we will be closing hopefully at 9:30. Now, but before we'll be closing at about 9:30. I can see the vice president of the Law Society is on, so I'll give him the microphone right now to ask his question.
Thank you very much, Edison, and thank you very much, Honorable Minister. Mine is not really a question, but just a few comments I intend to make. I hope you can hear me.
We can hear you loud and clear, Mr. Vice President. Loud and clear.
Perfect. Thank you very much, members. I'll first thank the Honorable Minister for spending all this time, and you must agree with me that Honorable Minister Mao is one of the few we have in Uganda who will give you all this time, and he will give you his candid discussion and with openness and honesty, and I really applaud you for that. And Edison, thank you very much for putting this together. I also would like to thank the members who are online listening. Maybe just to make the minister understand very well is that this is a product of our democratization campaign. Edison has been doing this for the members. I think this Judicial Service Commission situation has been a blessing for us. I would like to take the positive that even the delay in having our elections conducted has benefited members more because probably would not have had these engagements. If you recall, as a result of our RNB Executive Order number 2, that's when we did introduce this aspect of democratization and called for elections of our representatives to the Judicial Service Commission, and this was really, we had a good plan, and everything was structured. So this is an example of all that. If you look at also our other agendas, like the decolonization, I've had Minister Mao speak about so many laws that we have in place. He talked about law council, he talked about, you shouldn't forget about the ULS Act. All these laws we have, and we are still tying ourselves onto, a colonial relic, like the situation at law council. And I've had the minister talk about the suggestions and what ULS should do, and I can assure you we made these suggestions, but in most cases when we make these suggestions, recently I wrote a letter to the law council chair about the situation, the enrollment situation, and what can be done about it, with various recommendations. But the challenge is that these people are not open to discussion. They are not open to listening to advice from the voices of the people who have been on ground. Every time we come up with these suggestions, people will say these R&B people are mad. They don't know what they are talking about. But we are providing good solutions in the current state. So I like the fact that we're having a discussion where we actually touching all this, and it gives me a lot of, personally, on my behalf and on behalf of council, it gives us a lot of courage and hope that now we have people who really do understand. I also want to believe that Honorable Minister doesn't require converting. He's already converted, and he does believe in all these aspects of decolonization, and doing away with all these aspects which are a colonial relic. Now, I know it's been a whole discussion, but looking at the elephant in the room, which is the state of justice in Uganda, it's quite a huge topic. I am sorry I joined in late. I was attending to a meeting at Palu, but I had to rush and join in just to listen. I don't know how Ellison smoked me out. I noticed that I was present. I wouldn't want to be such discussions. But as I talk about that, as I make my comment, adding on to what the minister said, it's really about the independence of the judicial and the legal profession that is looming, and we really cannot hide from that. We keep talking about the autonomy of lawyers, and all we've been saying is that the autonomy of lawyers is, it has to exist with the autonomy of judges. They're like conjoined. You cannot have the bar alone and the bench, and this also speaks to the bar bench relations. I had the minister talk about the situations where we came from, where we are, how the opening of the new lawyer was such an embarrassment to all of us, and the picture it portrays out there. We need to know that much as lawyers might be autonomous, when the judiciary or the judge officers are not, the judicial officers are not, the vehicle of justice cannot move. We basically have to work together, and most of you have been following. Just last week on Friday, I together with the members of the R&B Council, we met the Chief Justice and had a few discussions, and it was I see the minister say the time is ripe for engagement and discussions, and these were our major focus. It was our major focus of discussion, the bar bench relations and the state of justice in the country, in the area of access to justice, what can be done in the wake of the massacre issue, which when I tried to raise earlier, some people felt it is an issue they should just ignore, but we said, hey, this is not something you can ignore. We need to work together, and I'm glad that the Chief Justice this time really opened up and said we can have a candid discussion, we can look for solutions together, because it's not enough for judiciary to think they can have solutions. We are the foot soldiers, we have members all over, we are the ones who experience all these. They need to look at it from the angle of a practitioner. why would the massacre people, for example, lay down their tools? They are not mad. They are not stupid, because at the end of the day, who does it affect? It affects members of the public, and both of us, both the judiciary and the lawyers, we are here to serve the public. We are aiming at one thing: access to justice. Of course, I know it is business for the lawyers, but who would not want to earn? In any case, the judicial officer will still earn their salary whether you go to court or not. But the lawyer that day probably will not even get anything, because the client will not pay knowing if not going to court. Other lawyers were standing a risk of losing, instructions. But I are saying, hey, this is just a symptom. It's a mere symptom of, a system that is almost broken down. Because as the Chief Justice always explains to us and has been explaining, the achievements, we are seeing an increase in the number of courts, an increase in the number of judicial officers. Even recently we saw new judicial officers being appointed. But then we are saying, is this going to resolve the problem? Is it solving the problem? At the end of the day, if you do not have consultations, if you do not consult, and I like the fact that the minister kept pointing to the need to consult law society when you're coming up with some of these policies, when you're making certain decisions, but there has been more of a deliberate move to make decisions without consulting, without reaching out to the law society. We have a mandate under Section 3 of the Act to advise government, to advise judiciary, but there has been that deliberate move to leave us out, and that's why we are saying we cannot sit back and keep quiet. It reminds me of one politician who said, if Parliament cannot come to the ghetto will come to Parliament, and that's why we are trying to use other means of being heard, which some people have actually misunderstood. They think the lawyers are being unruly. By the end of the day, if you cannot speak and fight for this independence, for this autonomy, because what we see in Massacre is twofold. There's an issue to do with autonomy of lawyers and autonomy of the judiciary, of the judicial officers. For example, if courts are not working, you had members telling you they are refunding. Some of them are refunding instruction fees. I don't think lawyers are conniving with the judicial officers. They are not working and will not get any business. But then at the end of the day, let's also be realistic. How do you expect to have a judicial officer, one judicial officer in a station, handling over 4,900 matters? Even if they work on a daily basis, even if they had, whatever number of cases in a day, it is impossible. Even if you brought in, the aspect of the performance appraisal, what will the person do? What much can they do? So it is important that we take cognizance of this. That's why you see even at the UN took it serious. We have a special UN rapporteur on the independence of lawyers and judges, and we even have a whole document about the independence of the judiciary. But unfortunately, in Uganda, most of the provisions of that document that was reached out through resolution of the UN, it's hard for which is the basic principles on the independence of the judiciary. It has so many provisions, including freedom of expression. Unfortunately, it cannot happen in Uganda, and rightly so. We are the ones who can speak. It's the lawyers who can speak for the members of the bench, for the judiciary, if there's anything wrong. But they have failed to see this, and this is why the challenge is. So we are saying that, listen, we need to step up, both as members of the bar, as members of the society, and stand tall, because if we cannot speak for the members of the public, then who will speak for them? You've seen what the impression and it's been creating. I mean, right now you all know our president is not in the country, simply because we have several cases. There's a judgment, a sentence of 2 years, and he filed several applications. After filing an appeal, he files an application for suspension of a sentence. Now, if an application involving the president of the Uganda Society can spend over 6 months without being heard, and then you find the day you have a chance and it is fixed, it is adjourned to 2 months, a mere application, and there's no clear explanation for that. What does that indicate? How about an ordinary person? We've been here talking about this, delayed justice. Sometimes people say the members of the judiciary are corrupt. One doesn't have to actually be corrupt, even if you're just perceived to be corrupt. But now, why would anyone think that this is justice if you're saying an application is going to be adjourned to 2 months ahead in August when someone has been waiting for over 4 months and there's no clear reason. Most of you remember we filed an application for habeas corpus for Aaron Kiza. That application has never been fixed. It is there pending. It is in court. So I think some of these problems are really self-created, and it's high time. I know, Honorable Minister, listen, it's high time you talk to these people. These are the discussions we had with the Chief Justice, and he promised that, you know, most of the things are going to be looked into. You find someone files a bail application and they take 6 months, a year without having it fixed. In fact, I was happy when he said the PJ should compile, a list. She should write to all the judicial officers around, and they get a list of all those, pending bail applications which have been in the system for 3 months and above. So then these judicial officers will explain why they can't even hear those matters. So I see where we are going. Like you said, we agree that we need to have collaboration and work together in improving, the lives of Ugandans, in improving the services we deliver. But that can only happen if we have proper backbench relations. I still don't see a reason why the president cannot be in Uganda. The president cannot be home. We have a whole president of the bar of the country simply because his own matters are stuck in court. Now, and people are saying if this is happening to lawyers, if we cannot speak for those who cannot speak, those who are voiceless, then what happens at the end of the day, the whole public is going to lose trust in the judicial system. And I believe all of us know what happens once people lose confidence and trust in the system, the judicial system. They'll begin taking matters into their hands. That's why I see there are increased cases of total breakdown of the rule of law, because people will go and look for solutions on their own. If you've been speaking to the ordinary citizen, they'll tell you, why would I go to court? I was reading a joke earlier where someone posted saying, I'm watching lawyers here, I'm watching a client wasting money on his lawyer instead of giving it to me. And this is a judicial officer speaking. So you see, even the members of the public have this belief of, if they believe that a lawyer is useless, I can get what I need without a lawyer. And have a judicial where the judicial officers believe you can work without lawyers. It becomes absurd, because at the end of the day, it's from the lawyers. It's you're first a lawyer, then you become a judicial officer. So really, I like the fact that now members are getting engaged in these discussions. People are suggesting solutions. For us, we are always here to give, and we've given these solutions, Honorable. Even the recent UPDF amendment bill, we gave our position. You've noticed our positions are very clear, backed by the law. But again, you find the challenges, you give your position and your advice, and it is not considered, it is not looked at. It's like it's inconsequential. But then again, all we are promising is, as the members of the bar, we are not backing down, we are not stopping. That's why we are still working against all those 4Ds. Yeah, we are working with the 4Ds, the decolonization, the democratization, and if everything the minister has touched, you must notice we've talked about it. He's talked about the LDC situation. This has been an issue, also an elephant in the room, where we've given our various opinion and what we think as the bar should be done. But like I said, when we say we are trying to be radical, when the president says we need to use radical means to get solutions because the normal ways have not worked, again, people do misunderstand. So I believe right now what we're doing as the Law Society, we are trying to use both. We are using the radical means to ensure that the message is sent home. But again, we are also engaging. People think we are not engaging. They are taking it the wrong way. They think we are fighting. It's not a fight. We are engaging because we believe we can get solutions from all corners. All we are interested in is ensuring that people deliver. The members of the public benefit from what we are supposed to be doing, and we do, because we have a statutory.
That is why you saw some of
the in our meeting, we agreed that now the Chief Justice has to convene a meeting involving all the stakeholders in the area of justice, or the justice sector, so that we have a better society. Otherwise, thank you very much. As I conclude, I also want to believe and call upon the judiciary, especially the Court of Appeal, to make sure this comes to an end. Our Judicial Service Commission representatives have been the candidates have been campaigning for, I don't know, forever. I don't know where Harrison gets the energy from, but like we say, nobody can stop reggae. But the energy is still there. But you can imagine all this is happening because our cases are stuck in court. They're not being, handled. But this is for the benefit, not for the benefit of the lawyers, but for the judiciary itself. So we really do call upon them to act and do their part for the ends of justice really to be met. Thank you very much. Over to you, Nelson.
Thank you, Mr. Vice President. For if you're just joining us, we have the Minister of Justice and Constitutional Affairs, the Honorable Norbert Mao. Maybe I'll give the next comment before Honorable you come in to Honorable Dr. Eli Karuhanga.
Just to tell you who this man you have is, because many of you just see him as a minister, as somebody on TV making comments, as a president of the Democratic Party, former MP, former chairman. But there is another person inside that facade called Norbert Mao, the individual. I want to tell you that I'm so happy and I'm awake because of that individual. I have known him, I have respected him, I have debated with him, I have admired him in the course of his journey in Uganda as a politician. From the early days as a child, I did not know him, but I've heard his story when he was speaking to the Christian lawyers, when he told us how at one time he wanted to jump off the bridge and end his life. But now I thank you because you have never been content to be ordinary, completely unmistakable as it is today. You never speak to impress people. You speak because of your conviction, you challenge, and you enlighten. I got worried about you. You had not gone for a diplomatic cocktail. You were just dancing with death. In fact, that time, one wrong word, you can bring the Chief Justice. I know him, a very good man. You can bring him, he can turn around. You can bring, as you said, bring the Speaker. You can even bring the Attorney General. Provision for lawyers to be on it in order to provide judicial services to bring justice to the people of Uganda. How can it be in existence without members of law society? And people find good sleep, those who are in charge. Please, my brother Mao, do what God made you for. Resurface and fulfill your destiny. I see lawyers plead cases for compensation of cases for northern Uganda, for the Acholi war claimants, for Teso. They finish their case and then they are being told you can wind up your matters and go. When they have spent 6 months in hotels in Gulu verifying, and just ignore them. Some of the things baffle me. I have personally attended some court cases. You have just been talking about titles being superimposed on top of others. Some of these places are crime scenes. Some of the ministries are crime scenes. They need scene of crime officers to go there and really condone off some of those departments. departments, playing about with the lives of the people of Uganda. That's why I turned to you, Norbert, and that's why I'm sitting here until 3:52. I'm in Korea. Colleagues, to be a minister is not an office where you are so important. The minister means servant. Try and convince colleagues in power that they are servants of the people. Let's help us to go through this storm. Restore order, bring integrity and justice in our country. Use your position not just as a Minister of Justice, but as a custodian of fairness in our land. Do you remember John Stuart Mill? He said, the worth of a state in the long run is the worth of the individuals composing it. Nobody should hide from bringing fairness to our society. I can't thank you enough for spending all this time talking to this audience. I have always seen you as an individual of worth. It is time for you to show it once again that your leadership is not measured in titles, but in the truth and in it your worth. You remember at one time sitting with you on NBS on a show, and I can see that Mr. Ari Sekatawa is on here with Ofono Pondo and others. You might recall that I was joking, but it turned out to be like a prophecy. You remember on that day, I light-heartedly and sincerely I said, the president should fish Mao out of Lake Victoria and make him a minister, since he had fished out others. I never thought I was prophesying. I didn't think it would happen. But to my astonishment, it happened. So when truth hides in humor, it tends to resurface as destiny. I am glad you got this destiny, and I want you. I want you to make sure that these pending cases in their millions in court, people being deposited for trial, and they stay there for 11 years without being heard. I want you to do everything you can to leave a legacy and to help us, because you have the support of these lawyers. I don't know how I can conclude this remark. I wish I could give you some statistics, but it's too late. I'm getting a bit too sleepy. But I want to tell you, out of honor, I am awake. Out of honor of you, I am awake. And our expectations of you and your support to Uganda is remarkable. Thank you so much. Thank you for being here. And thank you for giving me a chance to say something, Edison.
Thank you, sir.
Thank you, sir.
Thank you so much.
Thank you so much. You're welcome, sir.
Okay, I think we'll have closing remarks. I don't know if is Gumithri is that one?
Yes, Councillor Mo.
Maybe if you could just in a sentence, please. I know you've been waiting, but you'll bear with us. We've been with the minister since 7 p.m.
Okay, that's okay. Thank you so much for giving me an opportunity to speak a word or two here. I'm so much grateful for that. Just that my issues were a bit, they go back to enrollment, which Honorable Minister addressed. But personally, I wasn't that much convinced
with his remarks. He talks about the policies that are coming, the laws that are coming, and you can see these are they acting a long run. But we have people who are in the tunnel. We have people who have been waiting for enrollment for 1.5 years. They have not been, their issue has not been addressed. Honorable Minister has not given this immediate remedy to these people. He talks about the overwhelming applications, but the overwhelming applications, to me, with all due respect, that's what I would call a sham defense. Because these applications come in time, and then you tell me you have people who are employed elsewhere to come and evaluate the same.
Commissioners, I'm so sorry to interrupt you, but if you could just, I think so. The argument is well understood. Just if you could just in a sentence just put the question.
Okay, my question is, as the ministry, do they have an immediate remedy to people who are in the tunnel who have been waiting for enrollment for about 1.5 years? Thank you.
Thank you so much, Mr. Gomisiriza. You forgive me for cutting you short, but we have to close this. Over to you, Honorable Minister.
First, I wish to sincerely thank the Honorable Eli Karuhanga. We know how far away South Korea is and the time difference. I thank you for the challenge you have given me. It is a very sobering set of remarks you made, complete with advice. I welcome what you said. I know you are one of the few who would always meet me in the corridors and encourage me, because I used to smuggle in red label whiskey, and I was the smuggler. I would carry it to the bush to join him. And one day I carried a bottle, and Bishop Onono Nweng saw the bottle, and he said that I'm going to pray the bottle will break. And indeed, when the plane landed in the bush, the bottle broke, and then the contents spilled into a packet of biscuits. When I announced to Colonel Walter Ochora that this was because of the bishop's prayers, he said, I don't care, I'll now just eat the whiskey because it is all over in the biscuits. But the second bottle survived. Then he mixed it up with Joseph Kony's wild berries. It turned into wine. And I also joined in the drinking. We got a bit intoxicated, him getting very intoxicated. At one point, he started shouting at Vincent Oti. One time I heard him tell Vincent Oti, when we were talking about the International Criminal Court, Oti, shut up! And I told myself, this is the end. We are dead today. You know, in the middle of the night, you are surrounded by gunmen. And so I think we only went there because we thought, well, everything else has been tried. We may as well go. But we were encouraged by the fact that our religious leaders were there, and the traditional leaders were also there. Even where we are now, we are taking some calculated risks. The young people who are leading the Law Society now are standing up against very great challenges. So I really appreciate your wise counsel. We thank God that you are there to counsel us. We wait for you to return, and then we have a face-to-face. I embrace all the challenges you have thrown at me. Now, concerning practical measure, yes.
Do me a favor and do the country a favor and Law Society. Bring back Semakade. That young man has been elected. He has his term of office. It's about to expire, I suppose. But by bringing back Semakade, you bring back hope to this Law Society. don't get the president of lost sight of Uganda in exile.
Thank you very much.
Thank you very much.
I accept that challenge also. It is difficult, but it is our duty to make sure that he comes back. Now, in summing up, I want to assure those who are concerned about enrollment. We deal with cases also. What I spoke about the reasons why enrollment is slow, those are really not my own words. I was only telling you the response that the Secretary of the Law Council told the cabinet, and it is a reported speech. I believe in the truth of that, because any organization has challenges, but those who have been waiting for a very long time, it is still our duty to tell the Secretary of the Law Council to speed up the processes. We cannot run away from that. I did not mention those reasons as an excuse for doing nothing, but I thought I should also make a case for the other side. In fairness, we have to listen to all sides. This conversation will have to continue. Now, as I continued speaking, I got a message from another person who was listening to me. That is Esther Otada. Esther Otada challenged me and said, the greatest injustice is poverty.
Presented to me as well.
Yes, So our host also got that missile. I agree with that indeed the greatest injustice is poverty. Mahatma Gandhi said it even better. He said poverty is the worst form of violence. I think that nothing could have been said better, because poverty weakens more than any other thing. And that is why the government has woken up to these programs that are supposed to put money in people's pockets. I think next we need to talk about active citizenship in this country. You cannot count only on the elected leaders to fight for you. Citizens also have to have a stake in these things. We need a new civic culture. We need citizens who are aware of those who represent them. Last month, my son came home and he asked me, Dad, who is our LC1 chairman? Then I told him. Then he said, what about LC2? I didn't know. And LC3, and I mentioned the mayor of Makindye Sabagabo. How did this happen? They were in church praying, and then their team leader said, now pray for your leaders by name. And you say, God bless my LC1 XYZ, bless my LC2 XY, bless my LC3. I'm sure if I went around the table here, we would be greatly embarrassed. Yeah, everybody is saying pass. It simply shows that we are totally disconnected from those who actually have a duty to serve us. Many people do not know who actually has a duty to serve them, and that's the reason why everybody pours hot coals on the president. The president should come and do this. The president should come and do this. The truth of the matter is that most of these things should be done by us. Why should it be the president running around inspecting parish development model projects? The members of parliament, are they aware of the parish development beneficiaries in their constituencies? What about the LC3s? I think there's something we have got to do, and that is the way out of poverty, by ensuring that money has impact. Now the financial year is ending, the bulldozers are out on the roads because money must be spent. Roads that have been ignored for months, suddenly the potholes are being filled, because otherwise Ramadan Gobi will say, please send back the money to Kampala. So we need some, as we say, difficult conversations in this country. And unless we are ready for those difficult conversations, there is no way we can say that we want to build the country. That said, Ellison and your colleagues, in this conversation, we have really just scratched the surface. As for me, I want to pledge that as long as I'm pointed in the right direction, I'll do my best and we achieve our goals. But by the way, politicians are very good people. If you point them in the right direction, they will do wonderful things. Also, if you point them in the wrong direction, they will also deliver the disaster that you fear. I hope that for the duration that I still have in the Ministry of Justice, because for me, I don't have a constituency. I serve at the pleasure of the President, and even in Parliament, I'm MP of Kameme. I am not elected at all. But I hope today I've been able to paint in broad strokes, and I hope we have given some reason for hope for citizens. Of course, the best reason for hope is that we must protect personal liberties. There are things that I've been telling the judiciary, that every court session must begin with cases concerning the liberty of citizens. Before you call a land matter, before you call anything, I think every court should be open to cases concerning liberty. Bail applications, production warrants, those should be the very first cases. And the truth is, we are really Africans. I think we should allow even walk-in situations. The first few minutes, the way we have in Parliament, we have open mics, open question time, where any MP just asks any question on the government side. Imagine if we have a court where citizens go, and the first few minutes some citizens can put up their hands and say, you know, my husband has been in jail for this long, and then the judge says, clerk, what is this? Why is this matter? This is really the African way. We have got to Africanize our justice system. It may sound absurd or even chaotic, but there's an outcry out there. And that's why when the president goes out and calls a big rally and then says, do citizens have anything to say? I think that's the time when every government official gets diarrhea, because they don't know what the citizens are going to say about them. And I've heard some citizens making very strong statements denouncing officials that pretend that they are serving the people. In Uganda, I do believe that we have an opportunity to change direction. And the way to change direction is to go back to our constitution. For the first time this year, we want to work with everybody, including the Uganda Law Society, to celebrate what we call the Constitution Week. Let Ugandans know what the Constitution actually says. Having these talk show hosts saying all sorts of things. Somebody can say, today we want to read article this and that. Article 237, land belongs to the people. And then people understand that that is actually what the Constitution says. Somebody should talk about the role of the president. Do citizens know that the oath of the president includes a passage which does not exist in any other oath? To promote the welfare of the citizens of Uganda. It is only the president and vice president who subscribe to that oath. The rest of us don't have that line to promote the welfare of the citizens of Uganda. Of course, we do it in support of the president as the chief executive. But for the president, it is explicit. So I thank you again, Ellison, for this Twitter space. The dying minutes of the Twitter space were very solemn. Thanks to Senior Counsel Eli Karohanga. And I think by bringing the bigger picture, he has challenged all of us to stop this business of this judge has said this one has said this, and simply said the worth of a state in the long run is the worth of the individuals composing it. Those words should be emblazoned, and it should be in gold letters. And he also challenged me personally. Show that your leadership is not measured in titles. And I think these are words that I'm going to carry with me. And then he talked about order, integrity, and justice. These are, and then he says, we should not go around, saying, minister. My car has those two things, CM. Somebody said the CM means conman. So in my case now, I had to quickly say, no, it means Chairman Mao. Because we may laugh about it, but somehow that is what citizens tend to think about us. That how can CM mean con man, yet it is intended to mean cabinet minister. So when Honorable Eli Karanga says, do you know that minister means servant? Now that is a bombshell, because we are always the first at the buffet line. They say, now our guest of honor, please come and serve. Which is again contrary to our culture. Actually, in our culture, the king eats last, incidentally. So somehow we have turned things a bit upside down. I want to thank you so much. We are not in South Korea, but it is a bit late also for all of us. Thank you so much, and I wish you the best in this struggle. At least when you give a name to a disease, the medicine will be found. Yes. This is what you are doing. Thank you.
You'll try and do your best to implement it and see whether you can get a result. I know you are not just talking. I know you will do it, and I'm glad that these people have been able to sit down and listen to you. I'm so happy, because I know you are going to try your best. And I want you to start with my friend, my very good friend, the Honorable Chief Justice, because I know his goodness. I know that he could have been consumed by the moment, but I think that everything will be sorted. I believe in you.
Thank you, sir.
Thank you, sir.
Okay, I think it's now time for us to wind up this space.
And good night. And good morning.
Good morning, good afternoon, good evening, and good night for everyone. Usually, Honorable Ma, we play a song, but now, after the level and the depth of this conversation, I am almost embarrassed to suggest this song, because I usually suggest it about myself. So I will and I usually suggest it to members of the Law Society. but now I think the quality of the conversation has risen to such a level that some members may have answers to it, but nonetheless, with courage and boldness, I say to the members of the Law Society, Honorable Minister, usually to everyone who has joined us, good morning, good afternoon, good evening, and good night. Usually at this time, we propose a song, and I would have proposed, there's a song I always propose to members of the Law Society, but today I almost feel inadequate proposing it, but nonetheless with courage and conviction, almost shamelessness, I will propose this song about myself to the members of the Law Society. Moses Matovu's great Olimujawa Musaja Singanze.